Hello, everybody. Good afternoon. My name is Lauren Kluger. I'm an employment law partner and specialist at Reitler, Kalis, and Rosenblatt. I'm joined today for our webinar by my associate, Julie Vlotinger, who's on your
Hello,
screen.
everybody.
And it is April 15th, 2020. And we're going to talk today about navigating through this unprecedented health crisis with COVID-19 and what it means for your workforce, and some of the scenarios that you might be thinking about as an employer or as an employee about what to do with your workforce during this really challenging time where the global economy is really taking a hit, and your business is probably taking a hit, and it's affecting your ability to make payroll and to retain your employees, and you're thinking about what to do with those employees. We're going to be talking through a few of those scenarios, and those scenarios are termination or reduction in force. We're also going to be talking about furloughs, what they are, and if that's the right solution for your workforce. We're also going to be talking about salary reductions, cuts in pay for your workforce. And we're going to go through those three and try to give you some guidance to help you through these challenging times. And at the end of the webinar, we'll have the ability you can ask questions to me and Julie. There's a Q&A button on the bottom of your screen if you're on a computer. And if you're on an iPhone, it's on the top right corner, there's a Q&A. So you could submit a question. We'll have a little bit of time at the end for questions if you have any for me and Julie. And we'll try to address as many questions as we can. And hopefully you will find this webinar helpful and maybe a little comforting in these challenging times as well. So let's talk about the first topic, and that is terminations. A lot of you might be thinking about having to lay off many of your employees because you can't afford to pay them anymore. And as you've heard in the news, that's happening left and right. We here, the attorneys at Reitler, in the labor and employment practice have been quite busy helping our employer clients navigate through how to fairly do a reduction in force or terminate your employees. And I mentioned the word fairly because that should be top of mind for you when you're considering a reduction in force. It should be a fair process. You shouldn't target any particular employee based on a protected characteristic or a protected activity that they might have engaged in. It has to be a fair process, meaning you should engage with your CFO or your controller and have real basis in facts, neutral, non-discriminatory reasons for your decisions, such as the economic impact, and have the facts to back you up. Use your HR manager, use your CFO with the financial information of how these terminations will affect and help you navigate through this crisis. And if you have that, your decisions will really be very defensible in case someone has a claim of retaliation or some sort of disparate wrongful termination claim. You want to make sure that there's no disparate treatment amongst your employees, that you don't choose one employee over another for a discriminatory reason. You want to avoid all that. So you really want to be thoughtful about your process so that you can defend it in case you have to. It's also a good idea to engage with counsel on this, and all your communications with counsel would be protected by the attorney-client privilege, and you can speak freely with counsel about some of your decisions, and you can really have a gut check with your counsel, and they can help you navigate through what would be fair and what's a good way to go about doing it. You want to be able to show that the layoffs were economically necessary, and you do that by backing it up with facts from your books and your liabilities and your payroll, so you can be able to show that we really needed to do this to continue functioning as a going concern. That's not the test, but it should show that this is going to be, we need to do this to go forward. If you do decide to terminate your employees, I'm sure many of you out there have heard about the Payroll Protection Program, PPP loans that are out there. If you terminate your employees, you will not be able to use the payroll expense from the funds that you get from PPP. So that is a consideration for you to have when you're deciding whether you want to furlough or you want to terminate your employees. Also, remember, we are going to survive this, and we will be ramping up at some point and getting back to work. And if you terminate your employees, there's an expense to rehiring or engaging employees again. You know, there is light at the end of the tunnel, and that's going to happen. So that is expensive as well. So you want to have that be in play as well. And sometimes the furlough is a better answer for you rather than terminating your employees. So how do you let your employees know that they're going to be terminated? Well, you want to deliver this message in a face-to-face manner, meaning face-to-face nowadays is at a social distance, meaning digitally. So digitally face-to-face, it could be like we're doing right now on a Zoom call and a FaceTime, Skype, however you want to do it. It's a difficult conversation. It's hard, but I think there's one thing that's going on right now, and that is that employees are somewhat understanding about what's happening, and they will get it, and they won't be too surprised. But it's important to deliver the message humanely and with compassion, because it's a very difficult conversation. It's a difficult thing to undergo, losing your job. And the job market right now isn't great. So there's, it's difficult circumstances all around. So you want to have it face-to-face. Usually, a lot of our clients, what they're doing is having a group message from the CEO and to mostly everyone. And then they're going into breakout groups for the employees, supervisor, or immediate manager. You always want to have one or more. You want to have at least two people in that termination conversation. And after you have your initial group meeting, then you have the individual discussion with the supervisor or manager, where you can answer some more specific questions for that particular employee. And you want to have an open door policy as far as answering questions for your employees, because they will have a lot of them. So one of the things you want to consider, if you're in a position to do so, many employers right now are not, but one of the most important things to consider in a termination is whether or not you're going to pay severance. And if you are have the ability to pay severance, it's a good thing to be able to do that right now. For one, it gives your employees who are being let go a soft landing, and that's important right now with a difficult job market. And if you give severance, meaning compensation money, what you would give that in exchange for a release. So your employees would be giving you a release in exchange for that severance amount. And the release is important to the company because it releases, if the employees have any claims whatsoever, they're releasing the company. You have a clean slate, and you have a release of any claims. So that's a good thing. You have no liabilities hanging over your head. Particularly important if there are any employer companies out there who are undergoing a merger or an acquisition, and they want to be able to say to the acquirer, I'm squeaky clean. Look at all my release agreements. I have no claims, liabilities against the company. So that's a good thing to have. What does a separation and release agreement look like? It has to be documented, and that's a document that you present to your employee with the severance amount that you're going to pay them, and it contains a release in that agreement, a release of all claims. And we have a sample release that we can pull up on the screen. It looks something like that, a very long document, but the separation and release agreement is a full document of all kinds of relief that the company can get in exchange for this release. So you're making a payment that's included in that severance agreement, and you can also ask for non-disclosure. So the agreement remains confidential. You can ask for a non-disparagement in that release agreement, meaning the employee can't talk bad about the company or any of its directors or members. And you can ask for where jurisdiction would lie, and they can waive a jury in that separation and release agreement. So it's very beneficial, and it's very beneficial for the employer to get this release. And how do you calculate severance? So in the severance amount in the release agreement is it should be based on a uniform formula. So let's say 1 week for every year. So that's something to think about, what you're going to pay as severance. It doesn't have to be a week for every year. It could be whatever the company can afford, but however you administer that severance amount, it should be uniform across the board. Again, you don't want to open yourselves up to liability of a claim that you're treating one class of employees differently. You can treat employees differently as far as their years of tenure, whether they're executives, whether they're more rank and file staff. You can do that, but you don't want to do it based on a protected characteristic or a protected activity. Also, with separation and release agreements, you want to check your employee handbooks in case there's anything that's owed in those, such as accrued but unused vacation, and some state laws require you to pay that as well. That's all rolled up into the separation and release agreement. So you want to check your employee handbook as well, because a lot of your employees might know that handbook better than you do. And they'll know their rights. They'll know that if they get paid out vacation upon separation. So just be mindful of that. Check your employee handbooks. And any employment agreements that you have with some of your employees that you might be separating from, because those employees might have certain rights and certain rights to severance that you would have to comply with, for sure. So if you have employment agreements with certain executives, you want to comply with those agreements, and they would get a different severance amount than maybe your policy. So in addition to the separation and release agreement, for your employees over 40, they have certain rights with respect to the release agreement. So for those of you HR professionals out there, you know that when you do a separation and release agreement for an employee over 40, they're generally giving 21 days to consider the agreement. Here, they are going to get 45 days if it's a reduction in force, meaning 2 employees or more are being separated from the company. So they get 45 days, and they also have the 7-day revocation period. That's the same as if you're doing a one-off termination in exchange for a release agreement. So they still have that 7-day revocation period, but now it's 45-day consideration period. And the 45 days can be waived, just like the 21-day period can be waived. The 45-day, they can return, and they can sign that agreement right then and there, although that's not advisable because you want them to consult with counsel. And they have 45 days, they can return it sooner after they've consulted with counsel and they sign it. But that 7-day revocation period is not waivable. And you have to wait 7 days before you make any payments or the agreement is effective. So just wait out that 7-day period. On the 8th day, you can make your payments, however you're going to be doing that. You can make a payment in a lump sum, or you can make a payment in payroll. What's important about that is if you make the payment in payroll, that means that the severance payment will be made over a series of payments as pursuant to the payroll practice of the company. If the employee happens to breach the separation and release agreement, you can stop those payments because there will be a provision for that in the separation and release agreement. You could stop those payments, and you can ask for the payments back, and you stop paying any further payments. So if there's a breach, you're able to keep them on a short leash if it's if you're paying that severance in payroll. Or you could do a lump sum payroll, which is just a lump sum payment, which is just one lump sum after the effective date of the agreement for your employees over 40. For your employees under 40, you should just give them a reasonable period of time. There's no requirement that you give them any specific amount of time like there is under the Older Workers Protection Act. And also for the older workers, they're entitled to a disclosure chart. And we have a sample disclosure chart here. And for your employees over 40, for the departmental unit or the decisional unit, you have to give them the information here as to the others who were selected or not selected for termination and given a release agreement in exchange for a severance, and their ages. So you have, in addition to the separation release agreement that you will give them, you also give them this disclosure chart. So that complies with the Older Workers Protection Act. That's so your employees over 40 can make an informed decision about whether or not they want to sign this release agreement. Also, you just want to make sure that you have a date certain in your separation agreement to avoid 409A issues, that specifically when you're going to make that payment to the employee. So if it's when the revocation period expires or by a date certain for your workers under 40. And with that, I'm going to hand it over to Julie to talk a little bit about state requirements, particularly in California for release agreements and other state requirements.
Thanks, Lauren. So as Lauren mentioned, the release provision is a primary concern of the separation agreement. The sample release provision that was provided on the slides earlier, if you get a chance to review it, you'll see that there are certain specific federal and state laws that are mentioned that you want to get releases concerning, as well as the catch-all provision for any other claim. This is important to tailor it to the state that you are located in and operating in, and that the employee may be living in if that state is different than where you are operating. Also, certain states such as California may have specific language that must be included in any release agreement in order for the release to have its fully intended effect. California Civil Code Section 1542, which you see on your screen here, is a great example of that. This is very specific language that needs to be included in any agreement that will allow the release to be given according to California law. This language must be cited exactly as it is in the statute. This particular statute was recently changed in January 2019. So to the extent you have forms which utilize the prior version, those should be updated and corrected to conform with the new statute. There are also other considerations when we're doing a termination. Lauren mentioned severance, which is obviously at the most forefront of your separation agreement, but you also want to be mindful of other non-severance payments that may be owed to employees at the time of their termination. First and foremost, review your employment agreements and your employee handbooks to see what compensation may have been promised already to the employees in the event of a termination. You also want to check your state and local laws. Some states have state-specific requirements for employers to pay out certain benefits at the time of termination. For example, Massachusetts provides for mandatory vacation time, so accrued but unused vacation must be paid out to employees at the time of termination. That's not the case in New York or New Jersey. California also has a different spin on it. They do not require employers to provide paid vacation, but if they take on that choice, they are required to pay it out if it's accrued and unused. So really have to be mindful of the state and local areas where we're operating. Certain categories of possible payments that might be due to an employee upon a termination include, as we just discussed, vacation pay, sick pay, and the remainder of paid leave if the example I'm thinking of is if somebody has already decided that they want to take a certain amount of paid leave, whether that's maternity leave, paid family leave, other types of leave, you may be required to pay out the remainder of the leave if the termination comes in the middle of it. Other considerations that we should be mindful of are informing employees about open enrollment for COBRA health coverage, and whether, depending on how many employees you have, what state you're operating on, and the number and percentage of people that are being terminated, whether we need to give advance notice of the termination to employees under federal and state law. So the federal law that governs advance notice to employees is called the WARN Act. This is the Worker Adjustment and Retraining Notification Act. This is a federal law. It applies to employers with 100 or more employees, and it requires 60 days advance written notice of an adverse employment action that constitutes what's called a quote-unquote mass layoff. A mass layoff is any adverse employment action that affects more than 50 people or 33% of active full-time employees at a single job location. This includes termination. It includes temporary layoffs that are longer than 6 months, and it also includes reduction of hours more than 50% in a 6-month period. There's no particular form that needs to be submitted to the employee. It just has to be delivered by any reasonable method of delivery designed to ensure receipt. However, notices of these mass layoffs must also be given not only to the employees, but also to certain state and local officials. And those notices may have more detail in them that are required. You have to look to the law of each state to see which department should be receiving those notices. Sometimes it's the mayor, sometimes it's the Department of Labor. There are 3 exceptions to the WARN Act, which are circumstances in which the 60-day period is either reduced or not mandatory. Those are the unforeseeable business circumstances exception, the faltering company exception, and the natural disaster exception. I want to touch specifically on the unforeseeable business circumstances exception. This seems to have the most applicability to the current coronavirus circumstances. Basically, this exception says we will not enforce the 60 days advance written notice where the layoffs are caused by business circumstances that were not reasonably foreseeable at the time that notice would have been required. The best practice is always to give as much advance notice as possible, whether that's 60 days, 30 days, 2 days, as the case may be. It remains to be seen whether it will in fact be deemed to apply to COVID-19 concerns, but there's certainly a plausible argument for it. In addition to the federal WARN Act, different states have what's called mini WARN Acts. These are basically comparable advance notice statutes in certain states. Not all states have them. As you can see, California, Illinois, Iowa, New Hampshire, New Jersey, New York, Wisconsin all do. And basically, these mini WARN Acts are comparable to the WARN Act on the federal level, except they may apply to a wider scope of people or a lesser scope of people. It depends on the act at hand. For example, they may often apply to companies with fewer employees than the federal WARN Act would, which so federal is 100. California and Illinois apply to companies with 75 employees, whereas New York mini WARN Act applies to companies with 50 employees. The state WARN Acts may also have longer or shorter notice periods. Federal notice period is 60 days. New York requires 90 days advance notice, whereas a place like Iowa will only require 30 days advance notice. These different mini WARN statutes may have different thresholds for what requires notice. They may also have different or no exceptions than the 3 exceptions I enumerated before with regard to the federal act. For example, California and Illinois do not have any comparable business circumstances exception. So you really do need to look to your local and state as well as federal law to decide whether you need to give advance notice of the terminations to your employees. There are also certain states that have mandatory notice to local and state officials of a mass layoff, but not necessarily to your employees. And those, circumstances like if it affects 25 or more employees on one day for one reason, you have to give notice to your local and state office in Georgia, Maryland, North Dakota, and Tennessee. 50 or more employees in North Dakota. So just something to be mindful if you're operating in a state like that. One important provision I want to talk about is the recent Governor Gavin Newsom's executive order in California. He suspended the California WARN requirement given COVID-19 concerns. Basically, his executive order says that 60 days advance notice is not required if the terminations at issue are the result of a COVID-19 business circumstance that you could not reasonably foresee at the time of the notice. You still do have to give notice as soon as practicable, and any notice that is given under this statute must refer employees to unemployment insurance benefits. There's a quoted language on your screen there. In California, this language must be included in any notices that do not meet the 60-day advance notice requirement. Neither federal government nor other states have yet issued any similar suspensions of their respective WARN Act, but that may be coming down the pipeline. I guess time will tell. One thing we want to talk about is what happens if I don't give notice? What if I don't give enough notice? So the penalties under the federal act, at least, the liability to the employee would be back pay for the 60-day notice period, as well as the compensation for benefits for the notice period. It's not expressly written into the statute, but many employers choose to pay out 60 days salary in lieu of notice. It's not expressly permitted, as I said, but it is customary, although I guess you could still be liable if you don't pay the proper amount. You also have penalties for failure to properly notify officials up to $500 a day, and any litigant may be entitled to receive attorney's fees in the event they file a claim under the statute. There are similar remedies for mini WARN acts, though you cannot receive cumulative back pay should you file suit under both. The next thing we want to talk about is what benefits might your terminated employees have with respect to unemployment insurance. Terminated employees are generally eligible to receive unemployment insurance benefits, which are administered by the states. There are two recent state developments that are impacting unemployment insurance in the COVID-19 domain. One is that many states have suspended or waived traditional waiting periods before an unemployed person can begin collecting their benefit. There's usually a 1 or 2 week period before you can start. Many executive orders have waived that. The second interesting development is that Georgia is the first state in the United States to require that employers file their terminated employees' unemployment insurance applications for them. Certainly interesting. Have not seen it in other states, but again, who knows what could happen. The most important, arguably, development in unemployment insurance since the COVID-19 pandemic was declared is the coronavirus, the CARES Act, which we spoke about a little bit earlier before, but the Coronavirus Aid, Relief, and Economic Security Act. It was passed in March. It's a $2.2 trillion federal legislation designed to alleviate the financial impact of coronavirus. This particular statute expands, among other things, existing unemployment benefits by giving a $600 boost to any unemployment insurance benefits that you are already eligible to receive under state law, and that boost goes through July 31st. And it also adds 13 weeks to the maximum benefit period. Most states will have a 26-week period. Under the CARES Act, that would now be expanded to 39 weeks. There's also the pandemic unemployment assistance provision, which gives coronavirus-related unemployment benefits to employees who may not previously have qualified, such as independent contractors and employees of nonprofit organizations. With that, Lauren's going to talk about the other alternative to termination for your workforce.
Thank you so much, Julie. A lot of information there. So we're going to continue with the second scenario, and that is a furlough. So what is a furlough? A furlough is a temporary unpaid leave of absence. And we fielded a lot of questions on whether is a furlough the same thing as a layoff? And the answer is no, because generally a layoff is a termination of employment. So you don't have your employment status anymore. A furlough is an unpaid leave of absence, meaning you are still an active employee. All the terms and conditions and policies of employment still apply. So you are still an active employee. And that's basically the difference. So a lot of people think a layoff is the same. A layoff is not. It's your termination. You're terminated from employment. You are separating. A furlough, you're still employed. So the main benefit of a furlough is that you still maintain your benefits, and all you employers out there should confirm with your benefits provider that you can do that, because there are some eligibility requirements. However, on a furlough, you maintain your health benefits, you maintain your vacation pay. Now, your employee handbook might say while you're on a leave of absence, you don't get to accrue your vacation anymore. So you might not be accruing, but you're still entitled to take your PTO during the furlough. You're not required to, but you can. So as an employer, you have to give PTO if it's been accrued and the employee is eligible for that. Also, all the other terms and conditions of employment apply. So who do you choose to be on furlough? Same thought process as termination. You want it to be a fair and neutral, non-discriminatory process. You don't want to cherry pick who gets to be on furlough, who doesn't. You don't want to target anybody for any reason that's not legitimate. Meaning, and you want to consult with your HR managers, your controllers, your CFOs as to how these furloughs will best economically monetize the company. So it will best put you in the best position to move forward. And it's a necessary step. So if you have those facts to back you up in your decision making, you'll always be in a better position. And if you document it, you'll always be in a better position to defend your decisions, and if they're based on neutral and non-discriminatory reasons. We spoke before about when you're choosing who you were going to terminate, and the same thing applies for furloughs. And if somebody, let's say you have certain employees who are on other leaves, maternity leave, let's say, you are treating everybody the same, but you want to see out that maternity leave. So like Julie mentioned, if someone is on maternity leave, you really need to still comply with that leave, although they might be terminated at the end of the leave. And the same thing with furloughs. If someone's on a leave during a furlough, you have to pay out that leave. If they're on a paid maternity leave, you finish that leave and then the employee would be furloughed. So those already promised leaves still are in effect. So I said that there should be a fair process, and the same sort of discussions apply to furloughs as they do with separation from employment discussions. They're difficult discussions. Everybody's worried. Everybody's very stressed right now. You want to be compassionate in your discussion, and your employees are going to want to know, how long is this going to be for? And basically your furlough, in order not to trigger everything that Julie was just talking about as far as WARN Act and mini WARN Act notice requirements, you want that furlough to be less than 6 months. So that's the hope, that it's less than 6 months. You want the discussions again to be face-to-face. You could do a general messaging and then break it out with the employee's immediate supervisor and manager. You always want to have, at least 2 people in on those discussions and to be ready to answer any of the questions. The consequence of a furlough is the employer is able to really cut your payroll costs, which is a big expense, and you won't have that payroll protection program reimbursement claim if you furlough your employees, because you're not going to have that payroll expense. So that's just something to keep in mind under PPP, because I know a lot of employers out there are looking to get that reimbursement or the loan forgiveness for legitimate payroll expenses. This would not be, because you're eliminating your payroll. So how do you document a furlough? After you've had those individual discussions, you send a furlough notice to the employee of exactly what's going on. And you tell them that their benefits and all the conditions and terms of employment are going to stay the same, although they won't be getting their salary. And this is where you should consult with your employee handbook also, as far as seniority is still intact. And if you have a 401k matching, it's difficult for employees who aren't getting paid to put into their 401k. So they're going to stop doing that. So the employer's obligation to match those funds, it doesn't apply anymore, because you're not matching anything. And an employee can also take out of their 401k while they're on furlough. And under the CARES Act, they just raised that from $50,000 to $100,000. And that's for sort of adverse business circumstances, in addition to the regular coronavirus related illness eligibility. You can also take out if you're suffering adverse effects, business effects, financial effects from the coronavirus. And again, you should look at employment agreements if you have any, because you might trigger some obligations by eliminating compensation with your employee. We've also had a lot of questions from our clients about how is equity treated while employees are on furlough. And basically, you have to consult with your corporate counsel for sure, but you should look at the option agreements and incentive equity agreements, plans, and you should check to see how is equity treated while on a leave of absence, because generally your vesting will still continue for at least 3 months. This is not a severance of employment, so it's not triggering the exercise period because you're still employed. So it's important to check out your option plans, check out your any equity incentive plans, and consult with tax counsel, ERISA counsel, and corporate counsel on that. Also, under the CARES Act, employees are able to take out, if they have current loans, they can stop paying those loans for now, and those are being deferred for at least a year. So if you take out a loan or you are currently in a loan, you have some relief from that. A very real concern for employees is how long is the furlough going to last? So you don't have to make a promise. We advise you not to make a promise that you can't keep, but you have to know that it should not be longer than 6 months. So in your notice to them, you'll tell them that it's effective X date, that they won't be getting salary anymore, and any other specifics that have to be in that notice. And you're also going to want the employee to countersign or acknowledge that they got the furlough notice, that so you have an understanding from them that they know what's happening, that come April 15th they're not going to be getting paid anymore, although they're still going to maintain their benefits intact. And you could tell them that you hope that once business conditions improve, you hope to restore them, but nothing about the furlough notice changes the at-will nature of the employment or is a guarantee of employment. So that would all be in that furlough notice. And with that, I'm going to ask Julie to talk about state requirements for the furlough.
Sure. Thanks, Lauren. So as Lauren was just mentioning, if you expect that your furlough will go longer than 6 months, you will trigger the Federal WARN Act advance notice requirement. Furloughs are covered by the Federal Act. They may also be covered by some of the mini WARN Acts, such as California and New York. In both of those states, employment laws lasting more than 6 months or temporary work stoppages do qualify as a layoff subject to the mini WARN Act. There are also something to keep in mind if you're doing furloughs. There are certain notice requirements regardless of the duration of the furlough in specific states, not necessarily to the employees, but to state and local officials. Two such states would be Georgia and Maryland, which require notice to certain officials if 25 or more employees are laid off on the same, temporarily laid off permanently, more than 7 days. You do need to give notice to those state and local officials, regardless of how long it's going to last. Another consideration for your furloughed employees, and maybe something to weigh when you're deciding how am I going to proceed with my workforce, is that furloughed employees are generally eligible for unemployment insurance during the furlough period, much the same way that terminated employees are. One important exception to that is if you do a rotating furlough, where you furlough certain employees for 1 day a week or 1 day every other week. This could, in some states, have an impact. One such state would be New York. New York does not provide unemployment insurance benefits to persons who are working 4 or more days a week. It goes by the number of days worked, not the number of hours. So just something to consider when you're looking at your options between termination, furloughs, or the third scenario, which Lauren's gonna get into right now, which is salary reductions.
Right, so thank you, Julie. So the salary reductions, our last topic for today, is just like it sounds, reduction in salary or reduction in hours. Be careful not to cut your salaries too much, particularly for non-exempt salaried employees. In New York, the minimum salary threshold under the Fair Labor Standard in New York, and the minimum employees threshold is $58,500. And that means that you don't want to cut a salary for a non-exempt employee below that mark, or if they work over 40 hours in a given week, you'll have to pay them time and a half. So you just want to be careful of how much you cut their salaries, and just be, you might want to consult with counsel about that, but those are the basic minimums. You don't want to go below, or else you might, and if they're working over 40 hours, you're going to have to pay them time and a half. So just keep those numbers in mind. Also, when you're cutting salaries, you definitely want to look if you have any employment agreements, because you'll be in breach of those employment agreements, because number one, in point one in any employment agreement is how much is this compensation going to be. And once you fall below that agreed upon contractual amount, you will be in breach. So you might have to amend an employment agreement to reduce salaries, or look at those employment agreements as how you can make a change to the employment agreement. And you want to do that according to the contractual provisions and follow those. And you also want to look at your employee handbooks too, in case there's any implications from cutting salaries that way also. So cutting an hourly employee, you're just cutting the number of hours. And you also want to check with your benefits provider that nobody will lose their benefits by the amount of hours or the amount of salary they'll be. It would really come into play with hours. And again, these discussions, they're difficult to have, and they're a bit awkward, but same thing. You want to have individualized face-to-face discussions, following up with your written notice. And the written notice is going to say the exact time, the exact date that the salary reduction will be in effect, how long you expect it to last. Hopefully you can restore it at some point, but I would advise not making any promises. And you want to remind the employees that all other terms of employment still apply. It's just that their salary is going to be reduced at that time. And let me just see. Again, you want to have that the employees acknowledge it or countersign the notice. So if an email is fine, you can have them send that back, and that would be perfect. Okay, Julia, I think we just have one more point on reduction of salaries.
Yeah, so salary reductions, again, just want to remind everybody of that 6-month period. So under the Federal WARN Act, if you cut a salary by over 50% for longer than 6 months, those 60-day advance notice requirements kick in. But yeah, so the last point is relating to unemployment insurance eligibility for reduced salary employees. Most states do offer some form of partial unemployment benefits for someone whose salary has been reduced or whose hours have been reduced. Again, the exception would be New York, which looks to the number of days worked versus the lower salary amount. Another consideration as when you're looking at whether salary reduced employees might be eligible is whether their base level of reduced salary would ever qualify for unemployment insurance benefits. If you're getting $300,000 a year and your salary gets reduced to $150,000, it's probably not likely that you will be eligible for unemployment benefits, but you should always consult local unemployment offices for details as to whether your state will cover reduced salary or reduced hours circumstances.
Okay, with that, I'm going to open it up for some questions. I see that we do have a few. One question is, if an employee has a pending claim against the company, just move my screen. If an employee has a pending claim against the company, can you still take any of these actions? Well, yes, you can. Just because someone has a pending claim against the company doesn't mean that they are immune or that they're free from any sort of adverse action, particularly if they fall within your thoughtful process of an employee who should be included in a certain departmental unit or group that's being let go or furloughed. So you certainly should act as if the employee had not made the claim. However, this is where your separation agreement and releases come in handy, because you would offer that employee severance in exchange for a release, and they would release that pending claim. So that would be pretty valuable to you at that point in time. And you might want to think about having that particular employee who might have a pending claim in the group that's going to get terminated and offered severance in exchange for a release. So, you know, there's a lot of nuances to that. I can't tell from the question, but that's a basic answer for right now. All right, so let me see, there's another question. Can you address special rights, if any, that pregnant women or women on maternity leave may have if they are laid off for coronavirus-related reasons? Julie, do you want to handle that one?
Sure. I would say that there are no special circumstances for a pregnant or newly mothered person if the termination is related to the coronavirus. You know, as Lauren mentioned throughout, you want to make sure that when you're making these decisions, you have neutral, non-discriminatory reasons for making your termination, furlough, and salary reduction circumstances. You know, while it would be extremely unfortunate, I don't know that there would be any special consideration. Lauren, maybe if you can think of something different.
Right. Well, what we did say was if the woman is on maternity leave, presently on maternity leave, we really should honor that. That should be played out in any circumstance. So they're not in any worse off position. So they see out their maternity leave, and if it's paid, and there are certain benefits to the CARES Act, and actually it's a Family First Coronavirus Response Act, and you can have paid family medical leave for coronavirus related reasons only if the paid part is only if there's a school, if you can't work because of a school closure. So that's something different. In fact, we didn't have time for that today, but we're going to plan, Julie and I plan on doing another webinar another time that addresses paid family leave, paid sick leave under coronavirus. So we'll plan that. You'll look out for that on a future date. But as far as maternity leave, if anyone is affected by coronavirus, there is FMLA and there is paid sick leave in New York, and there's paid sick leave under the Families First Coronavirus Response Act, which is 10 days paid. So you get some sick time there, but that would have to be if you're affected by coronavirus, if you're caring for someone who's affected by coronavirus, or if you're affected by a school closure, and there's certain caps on those amount. But like I said, that's a webinar for another day. And this webinar will be available on our website, or it will be recorded and we'll be able to access it another time for those who might have joined late or want to watch it at another time. So we're going to have to close it out for now, and it will be available. So I appreciate all of your time. I hope that this was helpful and that you're all healthy and safe and continue to be so. And we thank you so much for your participation.
Thanks, everybody. Take care.
Bye.